Mark, is it true that most medical malpractice cases don't settle?
It is true, and it's a sad reality that it's true, but here are a couple of the reasons why. When a doctor has a claim filed against him or her, and a settlement or verdict is reached, there is a reporting to a national data bank that is, in essence, a negative check mark against that doctor's records. So doctors and the insurance companies who front the money to represent them typically dig in and will defend vigorously claims filed against them.
Previous in your career, were you on the defense side of medical malpractice? Because I know you're a plaintiff or patient lawyer now.
Yes, I am. I initially started my career in Massachusetts as a plaintiff's lawyer, but spent time in Virginia defending medical malpractice claims, which has given me a great insight as to the behind the scenes, if you will, from the plaintiff side as to what happens. And that has told me and taught me that insurance companies really listen to the doctors. And if a doctor says, I don't want to pay on this and I want to defend the case, I want to take this case to trial, well, then that case is headed to trial.
Well, give me the story from beginning to end. What's the basic layout of a medical malpractice case?
Here's how it goes. We first evaluate a case at the office to see if we believe as medical malpractice lawyers that a case exists. If we believe that it does, we then send the records to an expert to give us an expert medical opinion as to whether in fact the claim lies. If we get that positive opinion, then the lawsuit happens. The lawsuit is our ticket to court to present the case to a jury. Typically that takes about 1.5 to 2 years depending on where you are, but it is a paper-driven process. It's intense. We as your experienced lawyers know what to do, and let me just tell you, it's a complicated process, and you have to be very careful and very experienced to make sure that you hit the appropriate deadlines, file the appropriate papers, and get that case to trial.
That sounds pretty pessimistic of 1 year or more. Do some cases, a small percentage, settle without the lawsuit?
Some do, and the way we drive the settlement is to present the case as quickly and as strongly as we can. And our strength comes from our experts. We've been working with experts over years. We know the good experts, we know the experts who are persuasive, and when a doctor or an insurance company sees that we have a strong medical opinion supporting our claim, that leads to settlement. Those are the cases that settle.
What do you ask of the patient, the client? What do they have to do? What are their responsibilities?
If the case goes to trial, patients have to do 2 things. One, they have to answer questions, produce documents, that's called discovery. The second major step that a patient or client has to do is a deposition. A deposition is a dress rehearsal, if you will, of trial testimony. It's taken before a stenographer, a court reporter, who comes in and records your statements. We work very diligently with our clients to prepare them for that. Once that deposition is done, we put on our running shoes, get the case ready, and we go to trial.
What about economics? Do we ask clients typically to pay upfront costs to be a client of our firm?
We as a philosophy take the position that we're going to advance those costs. When we take your case, we believe in your case, and we show that belief through our financial commitment. So when it's time to pay those experts, we will advance those funds to get that done.
Is the client ultimately responsible for paying that back out of a settlement or recovery?
If we recover through settlement or obtain a verdict and collect that verdict, yes, there's reimbursement at that time.
If you or someone you know has suffered a serious personal injury, please feel free to contact us by going to our website or calling us at our 1-800 number. We'll be happy to help.